And so one of the things that we're dealing with in determining whether or not a guardianship is necessary is someone incapacitated. And so one of the things to consider is what they are able to do, what they are able to do, what they are able to understand. And one factor in that is if this person can understand, do we have the opportunity to do some advanced planning which would avoid the need for guardianship? And so where there is an age of onset before the age of 18, where the person has disabilities before the age of 18, that might or might not be possible. But one thing you can do is use a power of attorney potentially to avoid guardianship. And so a power of attorney is a document where you sign saying, I name so-and-so to make decisions for me with regard to my health and safety. Or I name so-and-so to make decisions for me with regard to finances. So if the person has the ability to understand that and to make those decisions, then you can do that in lieu of a guardianship. Now the guardianship affords you some additional protections that a power of attorney is not. If I sign a power of attorney that says my dad can go to, talk to my doctor for me or make decisions for me, that's fine, he can, but I still can too. Power of attorney doesn't remove my right to make those decisions. So where we have some of those vulnerability issues like Mark was talking about, where we have someone who's never met a stranger, where we're concerned of them being taken advantage of, the power of attorney might not be sufficient to fully protect them because yes, you can do things for them under a power of attorney, but they still have the legal right to do those things too, to enter into contracts, to make certain decisions. So power of attorney can be an alternative sometime, but if you've got these overarching concerns of vulnerability, then they might not be an effective tool long term for your child who has a disability.